So as real estate investors, how do you know where to file your LLCs in order to maximize your protection and the protection of your properties? Well, in this video, I'm going to tell you exactly where to set up your LLC and whether you should set up an LLC for each property or whether it's okay to lump them all into one. So let's get to it. Welcome back to Legal and Tax Strategies for Real Estate Investors and Syndicators. My name is Mauricio Rauld and I'm the founder of Premier Law Group. This question was actually submitted by Lewis, and it's an excellent question that's going to help us understand the all-important question of where to set up your property LLCs. So Lewis asks, I'm located in California and have 5 investment properties in Texas and 2 in Austin. In which state should I file the LLC that can provide maximum protection? Great question. This is going to be much easier if we have a diagram. So let's take a quick look at my impressive diagram skills. So I actually misread Lewis's question, and he actually has 5 properties in Tampa, Florida, and 2 of them in Austin, Texas. And so what I always recommend my clients is to always set up your property LLCs in the state where the properties are located. So in this case, I would set up the LLC in Florida. You could set it up in another state like California, since that's where you're from, or Nevada, or just any other state, but you would have to still qualify that LLC to do business in the state of Florida and register that LLC in the state of Florida. So you're actually having 2 separate sets of filing fees, 2 sets of maintenance fees, and there's really no additional benefit, because if anything were to happen to any one of these 5 properties, then let's say there's a slip and fall or a boiler explodes or whatever accident happens, then Florida law is going to apply because that's where the accident happened. So there's really no asset protection benefit to setting this particular entity up anywhere else. And the same thing with Texas, the Austin properties. I would just set these up in a Texas LLC and put both of them in there. Is it a good idea to put all 5 of them? We'll address that at the end of the video. But for now, I would be recommending setting up your Florida properties in the Florida LLC and your Texas properties in Texas. Now, for the ownership of these LLCs, I would definitely not have these in your individual name, especially if you live in the great state of California, which is probably the worst asset protection state in the country. These 2 properties LLCs would be owned 100% by another LLC that you own that conducts absolutely no business. It literally just sits there holding the ownership interest in the Florida LLC and the Texas LLC. It doesn't perform business anywhere else in the country. These LLCs are typically referred to as holding companies and are set up in the state that has the best asset protection laws in the country, which typically are Wyoming, Nevada, or Delaware, which is probably why you've heard those 3 before. This way, if something were to happen to you, irrespective of your properties, you got into a car accident, a business dispute, or what have you, and there's a judgment against you personally, then when it comes time for the creditor to come after your assets that are inside these Florida and Texas LLCs, Florida or Texas law wouldn't apply, but Nevada law would apply, or Delaware or Wyoming law, wherever state you set these up. And these 3 states make it very difficult for creditors to reach your assets. So in sum, property LLCs are set up in the state where the properties are located, and the holding company is generally set up in a premier asset protection state like Nevada, Wyoming, or Delaware. But is it smart to put all 5 properties into that Texas LLC? Here is what you need to understand. If something happened to one of those Texas properties, then the Texas LLC would be legally responsible, and anything inside that LLC would be fair game. So all 5 properties, any money in a bank account, and any other asset that the Texas LLC owns. In an ideal world, from an asset protection standpoint, each property would be held in its own LLC. So you would end up with 5 Texas LLCs with 1 property in each of those LLCs. That way, if something were to happen to one property, the other 4 would be insulated, and only that particular Texas LLC would be responsible. However, the challenge is cost. It costs money to set up the LLC, maintain it, and sometimes the LLC even has to pay taxes. And so it gets cost prohibitive if there isn't enough equity to justify those expenses. So you typically decide on your own, or with the assistance of your asset protection attorney, how much equity you're comfortable in losing in that particular LLC. For example, if all those 5 properties have, let's say, $100,000 in equity, but your net worth is $10 million, then it probably doesn't matter too much and you can put them all into the LLC. On the other hand, if that's all your net worth, you probably want to separate those out into separate LLCs. What I tell my clients is it's less about the amount of properties in each LLC, but more about how much equity is in each of those LLCs. On this particular example, generally speaking, you're probably going to see at least 2 LLCs, one with 3 properties and the other with 2. If you like this video, here's another one that I think you would enjoy on entity structuring for real estate investors. And if you found value, hit the like and subscribe button.